Hearing the 431 million Gauteng Department of Education schools decontamination contracts review application. The SIU wants a contract reviewed and set aside. Between June and August 2020, the Gauteng Department of Education spent more than 431 million on sanitizing schools. This money was paid in sundry payments to hundreds of companies, many of which appear to have no expertise or prior involvement in the cleaning industry. Let's now take you live to that hearing.
On top of everybody's heads of argument and papers. So what I intend then to do is possibly my oral address is not going to be quite as structured as our heads of argument. Your Ladyship will see there are three basic grounds of opposition. The first point to note is that we accept that the terms of the deviation, and I use that word advisedly because I'm going to address your Ladyship in the fact that the regulation 16A 6.4 does not in fact use the word deviation. It talks about other means. I'll deal with it in a moment. But what it required was accreditation for the services. Now, we accept candidly that the Chachulani respondents that received these contracts, some of them were on the CSD at the time, and some of them were later appointed to the CSD. But we also accept that none of them were accredited for decontamination and deep cleaning. For that reason, we do not challenge the formal invalidity of the appointment because, and our submission is slightly different, where a deviation has been given, an exemption from the normal provisions, then one doesn't look to the normal provisions, one looks to the terms of the exemption to see whether or not, and I think there was a submission between Mr. Chaskelson and your Ladyship as some sort of implied acceptance that to the extent that it's not expressly mentioned in the deviation, normal supply chain management apply, we say that's not necessarily the so. One looks at the exemption that is given, because it basically says you are free from the normal provisions, and then look at the exemption to see what part of the normal provisions are to be followed and what additional conditions. And depending on these circumstances, you may get an exemption to say you're free, but you can contract, but these are the certain mandatory things you have to have. And we recognize in that accreditation on the CSD for these particular services.
Yeah, but the national instructions, Mr. Peter, make it very clear that the fact that an emergency procurement procedure is also authorized does not mean that the principles of fairness, transparency, equity and competitiveness have to be dispensed with. And that is why a deviation is not a blanket license to simply depart from all procedures. The exemption is specified there.
Yeah, I hear what your Ladyship says. My submission is one must look at the circumstances under which the exemption is applied for and granted. Yeah. And the terms upon which it's applied.
Yeah, perhaps you and I should not spend a lot of time on this.
Certainly,
because we are not opposing the review relief.
No, but the point that I want to...
You raise quite substantive argument in relation to the relief you oppose. Perhaps that's where you should be investing your time.
I will do, but the point I need to make is because it has a bearing on the relief and what's just and equitable. So the first thing we look at is 16A 6.4. It says, if in a specific case it's impractical to invite competitive bids, the accounting office or accounting authority may procure required goods and services by other means, provided that the reasons for deviation from inviting competitive bids must be recorded and approved by the accounting office or accounting authority. So there we have expressly an exemption from competitive bids.
Yeah, but it says other means have to be authorized, right?
Yes.
And hence, the deviation should state what those means are.
Unfortunately, our deviation doesn't state it. But what we do know is that the deviation can only be given where there is impractical to invite competitive bids. So the idea of getting quotes for the idea for comparison is actually contrary to the express provisions of 16A 6.4.
I disagree. Are you familiar with the bidding process? In terms
The competitive bids, 16A 6.4, is in fact a departure from competitive bids.
Yes, a competitive bid is it follows quite an extensive procedure. You know, where it has to be advertised, perhaps in the open media. The advertisement must rather, there's a specific period within which bids must be submitted. It's quite an extensive procedure. So that is what is dispensed with. But that does not mean that the official that is implementing the deviation is at liberty to simply embark on any procedure.
May I say this, milady? Your ladyship has identified one method of competitive bids, but that's not the only method of competitive bids. That's some sort of public tender. But if you're going to buy pencils for one office, one doesn't advertise this in the Gazette. On those smaller contracts, somebody goes to the CSD, phones up, chooses 3 of suppliers at random, phones them up and gets quotes, and then goes with the lowest quote. On such minor contracts, no one's ever going to say that's...
But the amounts involved here, that procedure wouldn't be applicable.
Well, yeah, but that's the thresholds and trade. But I've given your ladyship an example that that's where you still get competitive bids. Here now we're in a national emergency and in a crisis. It's not they're not able to get competitive bids.
Yeah.
So they get a deviation. Unfortunately, the terms of the deviation didn't stipulate what they should have done, but it didn't forbid the state from setting a price. And there may well be times, I often get briefed by the state attorney, I get told what my rate is. It's not what I normally charge. And I must just either live with it or decline the brief. There's no negotiation there. And I accept that. And sometimes one does it as a national service, and sometimes one does it. That's the cost of doing business with the state. You have to accept some of their terms. That doesn't mean it's not competitive. Certainly not comparing one legal service provider's rates with another. They say that's the rate. And here, our people, all these respondents were phoned up and told that's the rate. So there's nothing sinister in that, and one shouldn't read too much in it, particularly, my lady. There's tremendous criticism, but it's Mr. Beloyi that formulated the rate, and his affidavit is missing. And it's not what had transpired with Mr. Beloyi and Mr. Mango that our complaint is. You want to criticize what Mr. Beloyi did. Where's the affidavit? Where's the interrogation of Mr. Beloyi? Where's the answer from the department or from Mr. Beloyi as to why this is so unreasonable? So that's the first thing. The second point to be made, and this leads into the other points of substance, is we accept on the basis of the non-accreditation, there's a case for invalidity. The SIU doesn't. So that means that the SIU considers the lack of competition and the pricing as a grounds for invalidity, which means that every service provider who was accredited and on the CSD would also suffer the same challenge, just on one less ground. But not one of these respondents is a service provider accredited in the CSD. So where is the SIUs chasing those people? And the answer is, the only reasonable inference is they don't exist, which then leads us to say, well, why was nobody contracted on the CSD accredited? And is there any evidence from the SIU that there was such a species of service provider?
Mr. Peter, let's get to your case.
Now, milady, that's very important because it goes to the discretion. One criticizes the department and you hold up your terms of your deviations, you had to contract somebody on the CSD accredited to these services. Well, prior to COVID, the question is, who was accredited on the CSD for decontamination and deep cleaning? It's something popular, it's very familiar to us now, but prior to March 2020, it wasn't.
Okay,
and
I'm start asking you questions, Mr. Peter. Okay, address me on the no-profit principle, please.
Right.
Or perhaps let's start with the jurisdiction point. I see you are persisting with it.
Yeah, milady, I must persist with
that
it.
you lost on it in the reconsideration application.
Yeah, the reconsideration.
Why in the same case?
Yes, milady.
And you're not saying why is Caledon wrong. You're still not saying Caledon River wrong.
Yes, Caledon River doesn't analyse the legal provisions we put in our previous argument, which your ladyship hasn't addressed in the judgment. One actually looks at the SIU Act, and it talks about, and we've listed all those provisions. It says this special investigator tribunal or any court of law. It doesn't say any other court of law. It doesn't treat the tribunal as a court. We've also identified PADGA, that the SIU's, the special investigator, the special tribunal's decision or decisions are one species of administrative decision, like prosecutorial decisions, which are exempt from administrative review under PADGA.
This is not an administrative process, Mr. Peter, and Caledon Properties deal with that extensively. This is an adjudicative process. It's not an administrative process.
But even though it's an adjudicative, it's still an administrative body that's doing the adjudication.
No, it's not. The appeals of this tribunal lies against the full court.
That's certainly true.
I'm a judge of the High Court. I'm not sitting here as an administrator. I'm sitting here as a judicial officer appointed in terms of the Constitution. Right? These proceedings are civil in nature. The SIU Act says so.
My lady, I must disagree with that point. Your ladyship, as a judicial officer appointed in the Constitution, can go and inspect a prison.
Yeah, but I'm not inspecting prisons here.
Yes, but
I'm here
the point,
deciding
absolutely,
over an adversarial procedure.
Yes, but in inspecting a prison, your ladyship's not holding court. Your ladyship is an adjudicative tribunal, but it's not a court, and especially set up that way. The tribunal, the Act doesn't refer to the tribunal as a court.
It doesn't have to. It doesn't have to.
Not only that,
River Properties have dealt extensively with reasons why this is a court in terms of Section 166E of the Constitution. It is other courts as envisaged in that section.
My lady, I'm not going to detain further argument on this because I'm aware that I'm not going to...
Perhaps you should be taking this point on appeal, Mr.
Absolutely,
Peter,
my lady.
Appeal not with you.
I will argue it on appeal. That's all I have to say about that point. But my lady, then coming now to the remedy. The first aspect is, let me just deal quickly with arbitration. That's completely incompetent. What they've asked for your ladyship to do is delegate the tribunal's adjudicative power to an arbitrator, which is just not
them on that point.
That's what I'm going to say. I'm going to leave that. Arbitration is something that parties agree to, and it's consensual, and that's how an arbitrator gets the power. There are provisions under the High Court legislation dealing with special referees. That doesn't apply here. And the reference and compelling people to go to arbitration is just, it's stretching Section 172 way too far. Right. My lady, let's then go on to the no profit principle. Why? This is assuming that the tribunal's got the power as a court to make the decision under 172(1)(b). What I haven't fully developed in the heads of argument, but the argument is slightly different from argued at the interlocutory stage, is we go back to all pay. All pay wasn't a case about the disgorgement of profits. And my learned friend has tacked onto that quote in all pay that you don't profit from an unlawful contract. But what's also important in all pay is that there was to be no loss. And the context in all pay and how the no profit principle and as developed in Shabangu, which with respect, my lady, your ladyship quoted Shabangu, but then didn't follow it in the interlocutory application. The genesis of all pay was this. There was a tender irregularity in the procurement. And because of 172(1)(a), there had to be a declaration of invalidity. And here the Constitutional Court was faced with a problem. The Latin expression, fiat justitia ruat caelum, let justice prevail though the heavens may fall. They were faced with that, and they weren't prepared to go that far. Because if they applied the law, declared this invalid, the heavens would fall, because they had now a practical problem. They stopped the contract, social grants wouldn't get paid, because the entire structure of the social grant distribution in the country was founded on this constitutionally invalid agreement. So now they were caught in a quandary. Because ordinarily, illegal contract, extirpi causa non oritur actio, you don't have a cause of action from an unlawful agreement. No further performance can be demanded from anybody, and one looks only at an enrichment situation. But here they had the problem. So how they skirted it is they first had to get round to the problem is how are we going to get all pay to cash paymaster services to continue providing, and they came up with the theory of, well, you've assumed constitutional obligations and you're performing a public service. And under that, guys, they said, well, no, you're not going to get out of it. But then they also needed to say, well, okay, that's their justification for not allowing the heavens to fall. We're going to suspend our declaration of invalidity until such time as somebody's put up some props to keep the heavens from falling, and then we'll make a declaration. And that's why they were given a time period. Let SASSA get a new system in place, and this contract must continue. So now they had the problem. They said, well, okay, you're not going to benefit from the unlawful contract. But Cash Paymaster Services was complaining that it was making a loss. One sees it is not expressly made in the judgment, but one sees it in the relief given. Not that you disgorge your profits, but one sees that the contention of Cash Paymaster Services has invested a huge amount in infrastructure, setting this up, and if it's cut short early, they're going to suffer a loss. So they say, okay, you can continue, but you give National Treasury your figures, and let's work out when you have or will make a break-even point. And from that point on, you're not going to make profits, but at least you'll recover your loss. So they were looking at a situation of enrichment. We're not going to penalize Cash Paymaster Services. The one question they never asked is, can the government or the organ of state profit from an unlawful contract? The answer, of course, is in Gijima. But as your ladyship pointed out, but that was not dealt with. So what they then did, and one doesn't see, you've got to account for profits. This is something taken to another level. The Constitution never said that you have to give a statement and a disgorgement of your profits. And then one sees that develop again in the Helen Suzman Foundation and the latest in Shabangu. And in Shabangu, His Lordship, Mr. Justice Froneman, distinguished between past and continuing. And one must see this no profit principle in two guises. One, it's not a principle on its own, but it is a remedy that was given under the rubric of just and equitable on certain particular circumstances peculiar to all pay. It's not some general principle of universal application, because ordinarily and particularly disgorgement of profits is a fiduciary remedy. You, the agent, you, the trustee, somebody who has a fiduciary obligation has profited when you shouldn't have. So there's an element of turpitude there. And then that's why you must give back, because it's wrong. Unjust enrichment doesn't always work like that. And it just depends where the cards fall, everything stops. Now we're dealing with past decisions. So that's the first thing I needed to make clear. Then we look at Gijima. Your ladyship is correct. And in paragraph 52 to 54 on pages 40 of the Gijima judgment, and I'm referring to the South African Law Reports 2018-223 at pages 40 to 41, paragraphs 50 to 54, they then look at it and they say, firstly, they've looked at the delay, and that was the most important thing, that the CETA, the organ of state, they acknowledge that it has to be declared invalid because of the irregular procurement procedure. But then they say, well, there was this tremendous delay. Under 172(1)(b), a court deciding there's a wide remedial power, any order that's just and equitable, so wide as it must be bounded by considerations of justice and equity, and it must count for a lot that CETA delayed. Also from the outget, Gijima was concerned, and as a result, CETA assured Gijima that it was proper procurement to be followed. And they say, overall, it seems to us justice and equity. So they're not looking at a no-profit rule. They're looking at justice and equity. That's the rule. No profit is one of the considerations in the application of a just and equitable. They say, just and equity dictate that despite the invalidity of the DOD agreement, CETA must not benefit from having given Gijima false assurances from its undue delay. And also importantly, Gajima may well have performed in terms of the contract while SETA sat idly by and only raised the question of the contract when Gajima instituted arbitration proceedings. In the circumstances, the just and equitable remedies, the award of the contract and the subsequent decisions to extend to be declared invalid with a rider that the declaration of invalidity must not have the effect of divesting Gajima of the rights to which, but for the declaration of invalidity, it might have been entitled. Right, milady, I don't profess to be as skilled in the arts of magic as the Constitutional Court, but it seems to me that they declared it invalid, but it's not invalid. But that's how it has worked, because the Constitutional Court has looked at practicalities, and under justice and equity, you cannot be too doctrinaire and dogmatic under section 172(1)(a). Yes, you have to declare it invalid and valid, but the ordinary declaration of invalidity doesn't apply in the constitutional sense because of the discretion. So ordinarily, if one were dealing with it as a court of law, to say this contract is invalid, you would say it's invalid, that's it. We are now left only in the field of unjust enrichment, and you have to treat the contract as void. Here, the Constitutional Court says, yes, it's invalid, but unjust enrichment is not even going to apply. You basically get the benefit of your bargain. So you're in the position as if the contract had been valid. And that's what they said. Gajima's position is not changed. So for the sake of form and declaring it for all to hear and see that this procurement was invalidly done, it's not visited with the ordinary consequences of invalidity. So that's a
patently clear. The reasons for that approach by the Concord are not patently clear from that judgment. I mean, I've read it back and forwards, and I'm really battling. I battle to understand why the different approach from OPE in Gajima.
Milady,
the fact that the context was different, I mean, the sense of...
My comment is this, milady, is I don't hold myself out as a leading constitutional lawyer like my learned friend, Mr. Chaskelson. Perhaps I don't want to deprecate Mr. Epstein, but I'm more in the commercial world. It looks to me like if you've got a void contract, then unjust enrichment applies. That's the law as I understand it. But we're in a new era in the Constitution, and it's justice and equity. And there is an overriding compelling, a court must declare something invalid. One cannot stand by and close one's eyes to a violation of the Constitution, because that's the supremacy of the Constitution and the rule of law. And that's our new constitutional dispensation. But there is a practicality element to it.
Yes.
One doesn't make those declarations and then cause the heavens to fall. One has to be practical about it, and that's where the just and equity comes into it. And that's what one sees. So if one extracts a principle, yes, one must make the declaration because that's what 172(1)(a) of the Constitution says we must do. But we are not going to be completely doctrinaire about it and ignore the practical realities of life, because we are a country getting on with the job of living as a society, and we have to navigate our ways. And this is a practical solution to being overly dogmatic about the declaration of invalidity. So yes, the declaration of invalidity is made, but not all of its consequences flow. Just as in the United States, if they strike down legislation, they strike it down.
Yeah,
it's done. It's unconstitutional. Here we say, oh, we'll suspend it.
Yeah, the point I'm putting to you, Mr. Peter, is that it's not patently clear why in Gajima the Concord opted to not allow the consequences of invalidity to follow.
Milady, my submission is this.
In the sense of divesting Gajima of its profit. It's really not clear why it didn't do so.
Milady, my submission is it's clear to me, and I'll offer this submission. Because it wasn't just and equitable in those circumstances.
But why?
Because SETA had sat by, they looked at the delay. So that on the specific facts, they come to a conclusion it's not just and equitable. On these specific facts, SETA had done and Gajima had performed. And the fault lay with SETA, not with Gajima. And which is a principle here.
But that's an issue that arises in all these procurement matters, in most of them actually, where the tenderer is completely oblivious to the defects in the procurement process.
Absolutely, milady.
So that cannot be. And it cannot be that where a tenderer is oblivious to the defects, then the tenderer should not be divested.
No, milady, I'm not saying
was oblivious.
No. Let's get the situation where the tenderer is innocent and oblivious. Then one looks at you're dealing with an innocent person and the fault lies at the state. We're not talking about a corruption where there's collusion and the tenderer has bribed, because other considerations play, which I've spelled out in the arithmetic that's in the heads of argument. But let's look at that. If the contract is fully performed, then you say you've got the contract been fully performed. Yes, I declare it invalid. This tender is completely oblivious. What do I do now? Under ordinary principles of contract, there was an invalid contract, full performance. It's only a question of enrichment. And if you got the benefit for your bargain, you would say, well, look, I performed because I believed it was, I thought I had an obligation. I didn't know it was invalid. I want my performance back. Then you must tender your performance back. In a contract like this, which is not a sale, where you've got the thing which you can tender, but you've consumed the service, you can't tender restitution. So you come with a condictia.
Yeah, but let's look at this in the context of the Proclamation 23 cases, which all arises in the context of COVID, right? The value of these the tenders that are being investigated by the SIU under this proclamation presently, and this value could easily increase because the investigations are continuing, is 5 billion. Now, when you consider this huge potential loss to the state within the context of the purpose of the SIU Act, it cannot be that because the tenderers were innocent, they have all performed, which they should have because the procurement was urgent. They should then, or the state should simply lose.
Yes, my lady. Your ladyship highlights a very important point, which I need to develop. Your ladyship assumes that what is paid.
My point, Mr. Peter.
No. It's not your point, but your ladyship highlights a very important point, which I've addressed in the heads of argument, but I wish to develop here. Is the argument is made with Mr. Chaskelton's emotive statements of feeding frenzy. The money that was paid is not necessarily a loss. It's whether or not, the real question is, did the state receive value for money? So when we're dealing with an innocent tenderer, and I just used the figures, the state paid 120. The fair, reasonable market price is 100. My submission is, in that case, you give the state a condictio. You say, we paid you under an invalid contract. It's the condictio sine causa. You paid you 120. You've been enriched by 120, being paid by 120. We got value of 100. Pay the 20. That's my claim. If the tenderer says, yes, it may have been, but my expenses were 105, he must disgorge 15. But the starting point is the difference between what was paid and fair market value. If the state has paid 100 and received 100 from an innocent tenderer, you don't deny the tenderer his 5 or 10 or whatever his profit is, because the state is not out of pocket.
We're coming out of that, the process there, starting with an interrogation of the emergency procurement procedure and whether or to what extent it overrides normal provisions of approving tenders. A bit of wrangling, clearly no agreement here. The Special Investigating Unit hearings on the 431 million Gauteng Department of Education school decontamination contracts review application. The SIU wants the contract reviewed and set aside. Between June and August 2020, the Gauteng Department of Education spent 431 million on sanitizing school. This money was paid in sundry payments to hundreds of companies, many of which appear to have no expertise or prior involvement in the cleaning industry.